My name's Lee Perlman. I'm a consumer bankruptcy attorney. I've been practicing bankruptcy law since 1994. I've helped thousands of people in the state of New Jersey deal with foreclosures, wage garnishments, bank levies, and give them breathing room and a fresh start. I want to break down the two kinds of chapters. I want to demystify bankruptcy for everybody today. There's a Chapter 7 where no one's paid back, and there's a Chapter 13 where payments have to be made. There's a Chapter 11 for a business. We won't discuss that today. So for a Chapter 7, I like to say there are three boxes that have to get checked. One is something called a means test. So for simplicity purposes, if you're a single individual in the state of New Jersey, you can't be earning much more than $75,000 or so and file bankruptcy. More than that, you could be disqualified and have to file a Chapter 13 and make payments. Two, you can't have too much equity in your home or your car. What does that mean? That means that if you have equity above and beyond $25,000 or $30,000, when factoring in cost of sale and taxes, you may have too much equity to file Chapter 7 and could have to file Chapter 13, which we'll speak about. And then the third box that has to get checked to decide if and when and whether you qualify for a Chapter 7 is really, it has to do with your budget. Are your expenses reasonable and necessary? Are you buying all your groceries at Whole Foods? Do you have a $750 BMW payment? Are you sending your kids to private school? So certain expenses are going to get flagged as not reasonable and necessary. If your expenses are reasonable and necessary, rent, food, utility, insurance, typical rent, typical insurance, typical car payment, and your expenses are reasonable and necessary, and when you look at what's coming in and going out, very little left over at the end of the month, likely a Chapter 7. So what's that process look like? You engage a lawyer. The lawyer should be able to know right away which creditors are contacting you. You want to make sure that creditors, you have a lawyer who's going to be proactive so that creditors can't call, write, sue, garnish wages, levy on your bank account. If the lawyer is not enforcing your consumer financial protection rights as soon as you are hired, he or she's not doing their job. What are some of the advantages of a bankruptcy? Well, like we talked about, you get breathing room and a fresh start right away. As we discussed earlier, it's very, very common that the financial distress that many of my clients see, it leads to physical distress and mental manifestations, psychological problems, getting breathing room and a fresh start. You cannot underestimate the value of that for many of my clients. So, what do you lose in a Chapter 7? Typically not much. And we talked about your home and your car are mainly protected. Also, we talked about the fact that the impact on your credit is not as bad as you think. So overall, you have to determine whether you qualify for Chapter 7, where no one's paid back, Chapter 13, where you have to make payments. What kinds of debts can you get rid of in Chapter 7? Well, you can discharge or get rid of a lot of consumer debt, doctor and hospital bills, credit cards, personal loans, repossessions, past landlords, unsecured debt, debt that you didn't pledge collateral for, debt that you incurred where you didn't say, I'm giving you collateral like a house or a car. In most cases, this is the debt that you can get rid of. Can I own real estate in a Chapter 7 and still file? Yes, yes, yes. In most cases, if the home has very little equity and you're current, you can file a Chapter 7, provided you meet the other guidelines. What happens if you file a Chapter 7 and you're behind on a house and you want to get rid of it? You can surrender your house in a Chapter 7. Or you can file a Chapter 7 and seek a loan modification. So there are some opportunities in a Chapter 7 with real estate. To say point blank that you file Chapter 7 and you can't have real estate is incorrect. And any attorney who's going to tell you that that's the case doesn't understand what they're doing.